Hi, my name is Barry Weber, and I'm an attorney and CPA in the Fresno, California area. And I want to talk to you just a little bit about providing for your children while you're alive and if you die. This is not intended to be a comprehensive coverage of the topics. It's only intended to be an introduction to basic concepts, and there's no intent to form an attorney-client relationship with you or give you legal advice. Now, the first thing we're going to talk about is appointing a personal guardian for your minor children. And this pretty much applies when you die or become incapacitated or something major happens that you or the court need to appoint a guardian for the person of the minor child. Now, usually a surviving spouse, if there is one, will be appointed sole custody unless she's unfit or has legally abandoned the child. A personal guardian can be nominated by you and your will, and that's one of the main reasons that you need to construct a will if you have minor children. The probate court still must approve the selection, but great weight is given to your nomination. If there's no will, the court will simply appoint a guardian. And a grandparent can't even nominate a property guardian for the child. Now, the other thing to consider, and this is a little off the subject, but medical powers of attorney for children. Now, there's situations where you have somebody else take care of your kids and a medical emergency comes up and you can't be contacted. You need to execute a medical power of attorney. It's a simple form. There's forms on the internet, and give it to that person so the medical providers will honor their wishes as it relates to medical provision of medical services. Now, in the first slide, we talked about appointing a guardian for your minor children. Now we're going to talk about leaving property to your minor children. And there's three basic options. You can just simply leave the property directly to the minor children. In fact, you could give it to them during your lifetime. You can establish a Uniform Transfers to Minors Act account, which we'll talk about. And you can transfer property to a trust for the minor, which is the most popular way to do it. So what are the problems with giving property to a minor? Well, contrary to popular belief, a minor can inherit and own property in California, but the court's going to supervise that property until the child's 18. They'll either, in the case of cash or small amounts, small estates, they'll put it into a block bank account where the account can't be accessed until the child's 18, or they'll appoint a probate court guardianship over the child or over the property of the child. And then you have the expenses of paying for the guardian and all of the inherent problems with the probate. You're going to have, if you give a property directly to a child, there's still going to be problems contracting for and managing the property. The child can contract in California, but in California, a child can disavow that contract entered into when he was a minor or for a short period of time after he turns 18. So it makes it very dangerous for somebody to enter into a contract with a minor. And a minor cannot make contracts related to real estate and some limited personal property. The biggest problem is, even if he could, there's no adult management. Most children are at the less than 18 years old are not sophisticated enough to manage any amount of property on their own. And if a property guardianship must be appointed, the property must go through probate. You also have a kiddie tax issue where a minor receives under an income during your lifetime, and that's beyond the scope of this presentation. Now, the first alternative to just giving property directly to a minor is to establish a custodial account under the Uniform Transfers to Minors Act, or UMTA. The donor, or the person giving the property, can gift any property or money into the UMTA account in the child's name. It can be left by will or by living trust, and it can be for any minor, not just a family member. The child is considered owner of the gifted property, and the property is held, managed, and distributed by a custodian appointed by the donor. That custodian has authority to use the property for the use and benefit of the minor. The custodian is entitled to compensation, so there's expenses involved in doing this, but no court supervision is required. Disadvantages of a UMTA account is that the property is distributed outright with no strings attached when the child either reaches 18, or if the gift was made by will or trust by the donor, and it so says, the distribution could be delayed to the age of 25. But at that age, 18 or between 18 and 25, property goes without any strings to the minor. There's no contribution limit for gifts to a minor under the Uniform Transfers to Minor Act. The gift exclusion of $15,000 still applies, and any excessive gift over that amount, it applies toward the unified credit. Now, with the new unified credit rules going up substantially, for most people, that a gift in the state taxes isn't going to be an issue. But if it is, there's a 5-up carryback contribution allowed, where you can deduct, or you can contribute 5 years worth of contributions at one time as a makeup. So when do you use a UMTA account? Well, the UMTA account, UTMA account, is simple and it's less expensive to set up. You just go to a bank or a securities company that does them, and you fill out the forms. And it's appropriate for smaller estates. The income in a UTMA account is taxed at the child's tax rate. And it's especially appropriate for life insurance proceeds. If you name your minor beneficiary the beneficiary of a life insurance policy, the policy it needs to be managed if something happens and the minor receives it. By transferring it, by naming the UTMA account as the beneficiary, that's taken care of. The disadvantages, of course, of a UTMA account is that the property cannot be held beyond the age of 18 to 25, as we discussed. There's no limitation on how the property is used after it's distributed, and you can't have a second beneficiary. So if something happens to the child, you can't appoint an alternate to receive the property. Now, the other alternative, the third way of giving or leaving property to children, is by establishing a children's trust. Now, these trusts can be revocable. They can be a living trust established during your lifetime. You can change them as long as you're alive or you're not incapacitated, and the assets transfer avoid probate when you die. Now, there's another way to do it, by testamentary trusts, and those are trusts created by will, and they're not commonly used because they don't avoid probate. And the court will continue to supervise the assets in the trust for the length of the trust. Now, there's some advantages of a trust over a UTMA account. There's no requirement in a trust to distribute the assets at majority. In fact, the trust can hold on to the assets for quite some time. But if income is not distributed out of the trust to the beneficiary, it's taxed at a higher trust rate. A trustee can be given discretion as to distributions. You can create a family pot trust, and this is just simply a revocable living trust where the trustee, where you leave the money to two or more in one common fund, and the trustee has discretion to spend any amount on any child as the need arises, according to the trust terms. Most pot trusts last until the youngest beneficiary is 18, and it can convert to a regular trust at 18. Now, I want to talk just a little bit about special needs trusts. And I'm going to cover this in more detail in another seminar, but this is just a basic outline. But in the situation where you have a child, grandchild, or whomever that has special needs, it has disability, and the child qualifies for SSI or Medi-Cal, a special needs trust is designed to allow spending for the child without disqualifying him for government benefits. The beneficiary, the child, has no control over the assets and is never the trustee. The beneficiary never owns the assets in the trust. The property of the trust can be used for needs not paid for by Medi-Cal or SSI without interfering with the Medi-Cal or SSI qualification limits. You can't give money directly in what's called a spendthrift trust, and it basically keeps the assets out of the hands of the child, but still allows some benefit to be passed to him. There's another variation on special needs trusts, and this is pretty new, and it's called the ABLE Savings Account. It's simpler, it's easy to set up, but there's some limitations. The ABLE Savings Account allows money to be set aside for persons disabled before the age of 26. So the disability had to occur before 26, but the the savings account can be set up at any time. The beneficiary must meet the SSA, Social Security Administration, definition of disability. Now, each state administers its own ABLE program, and California has authorized theirs, but is still in the process of implementing it. But you can set up a ABLE account in another state, but you can only have one ABLE account. The funds that you put into the ABLE account don't count towards the SSI Medi-Cal limits. The person, unlike a special needs trust, the person with the disability can control his own account as far as what's being invested in, with some limits. There's some limits as to how much you can put into the ABLE account. Total deposits from all sources are limited to the annual gift exclusion, which is $15,000 in 2018. So, and that's per beneficiary. So if 2 or 3 people establish ABLE accounts for that beneficiary, the total of the contributions can only be $15,000 in a year. There's no income tax deduction for contributions, so these are after-tax contributions for the contributor, but so there's no tax savings. And if the beneficiary is also receiving SSI, there's a $100,000 limit as to how much can be in the ABLE account. There's a couple of ways to provide for the education of your children, and these can be done at any time. They're not necessarily related to death, but they can be. They can be used. A 529 educational investment plan, which is a newer mechanism, is used to pay for qualified educational expenses of a named beneficiary, and that person must be a family member. Now, under the old rules, it used to be called a college savings account, and it was limited to college expenses and graduate school expenses. But now it can be used for K through 12 or vocational schools, and it even can be used for home study. The after-tax contributions allow the contributions are made after tax, so there's no tax savings on contributing to a 529 account, but it allows tax-free withdrawals from the plan as long as they're for a qualified educational purpose. And you can spend up to $10,000 per year for qualified educational purposes. If you spend more than that, there's tax penalties, and they apply also if you withdraw money for other than qualified educational purposes. There's no age limit on when the assets must be used. The contributions are considered a gift to the child, so they're not part of the contributor's estate anymore. And any amounts that you can't use can be rolled over to another beneficiary family member. So if one beneficiary doesn't use the amount in his 529 account, it can be rolled over to another qualified beneficiary family member. The disadvantage of a 529 account is because it's a state-sponsored account, there's only a few options as to how the money can be invested. Unlike an IRA, where you have a almost limitless number of investments, ABLE account investments are very limited. Now, the old Coverdell account is another educational savings account. They're still viable. There's some limits that don't apply to the education of the 529 accounts. Contributions to a Coverdell account are limited to $2,000 per beneficiary annually, and there's a phase out for high-income parents. The child must be under 18 when the contributions are made, and there's a 6% excise tax for excess contributions over the $2,000 limit. Like the 529A accounts, contributions to a Coverdell account are not tax deductible when made, but there's no tax due when withdrawals are made for educational expenses. All distributions are made to the beneficiary. Any funds not withdrawn when the child reaches 30 must be distributed subject to tax and a 10% penalty on a growth account. But you can avoid the tax and penalty at age 30 by rolling the account over to another qualified family member under 30. In a Coverdell account, unlike the 529 account, the parent can use the money for any investment desired. But the financial institution, like in an IRA, is the custodian of the account. You can transfer funds from a Coverdell account into a 529 account without penalty, but you can't transfer funds back from an educational savings account to a 529 plan. So where to get more information? You can visit my website at www.barryweberlaw.com. You can send me an email. The address is on the screen. And I'd be happy to schedule an introductory consultation or meet with you by person or by phone to discuss this or any other concerns you may have. Thank you for listening to my webinar.